Raven Queen, Antonio Washington, Denzel Lee, Sean Jackson, Antoine McDuffie. All right, so for the state, we have Mr. Ports appearing. I'm going to start with page 27. Mr. Rasmussen, for Ms. Queen, this is the #1 co-defendant. Mr. Rasmussen, are you remaining on the case?
What, are we what?
Are you remaining on the case?
I'm not. Mr. Langford is on the video.
Okay.
He's going to be substituting in this week, but I'm going to argue this morning.
Sounds good.
We just didn't get it accomplished yet, so I'm still here.
So you're going to argue, and then I'm going to withdraw you? Is that the plan? And then substituting Langford on the record? You'll just do it yourself? Okay. Okay. I did not get a written opposition or written motion.
Yeah, right. I received the state's opposition to my oral motion on Friday, and I'm prepared to basically argue. If you'd like me to start, that's fine, because it was initially my motion. If you
go ahead.
Want the state to start, that's fine as well.
You can start. On a couple of these, we're in different postures, so I'm going to have questions to start with Mr. Ports, but on this one, I'm going to start with Ms. Rasmussen.
Okay. So here's what I think should happen with regard to bail, and I don't know that it's happened, although I will admit that I was not part of the Henderson Justice Court proceeding. So in Henderson, there was a $500,000 bail set. And then with the superseding indictment, it moved with regard to Ms. Queen from $500,000 to $1 million. I don't know what prior counsel argued, if anything, at the Henderson Justice Court proceeding. But here's what I can tell the court. My client is 28 years old. She lives in Los Angeles. She basically lives with her elderly grandmother, helps take care of her. She does not have any resource that would support a $1 million bail. She couldn't make a $500,000 bail, let alone a $1 million bail. She couldn't make a $250,000 bail. She cannot do high-level monitoring. I feel like there was no individualized particularization here because she lives in Los Angeles. So high-level monitoring wouldn't work because she doesn't live here. There are things that could work. For example, the court could order her not to come to Nevada unless she has court. The court could order her on house arrest in Los Angeles. There are other things that the court could fashion that are more particularized to her and her situation. She was indigent, which is why she had appointed counsel. The family has scraped together money to retain me, and now that's going to go to Mr. Langford. But there's no the $1 million bail. Like, I have murder cases with a lower bail setting than $1 million, and I understand that the allegations in this case are serious and they're frightening. I'm not trying to minimize that whatsoever, but what I can also say is that there's no instance where Ms. Queen is alleged to have been present at any of these events. Now, I understand the state's theory, which is that she was somehow in the background organizing things, but she's never present where guns are discharged or guns are used to beat people over the head or people are held underwater. She's never a part of any of those incidents. I have read, I don't have, for the record, the transcript from the superseding indictment, which was February 17th is the day of the indictment return, so I'm assuming that proceeding was February 16th. We don't have that yet, but I read from their motion that these are the allegations. But in none of those instances is she alleged to have actually been present. And so there are, Your Honor, obviously some legal issues under Golden and Sharma with regard to the state's reach, with regard to her as a defendant in this case. But more importantly, there's simply no basis to set a $1 million bail that this indigent defendant would never be able to make. And to add, to just add high-level monitoring on it, what it tells me is that this bail setting occurred without any individualized thought as to this defendant. So I would ask that the court fashion conditions that it would deem reasonable, given that she lives out of state, and set the bail no higher than $100,000.
Thank you, Ms. Rasmussen. Turning to you.
Thank you, Your Honor. And Defendant Queen is the ringleader of this group, run multiple different groups as they're committing the crimes that we've outlined in detail within our motion that we presented to the court. I would note, Your Honor, that the purpose of bail, as highlighted in Valdez-Hernandez, is to secure the defendant's presence as well as protect members of the community. And that the defendant, while we must consider their financial ability for any of these defendants to make the bail amount set, we are not, the Constitution does not require a setting of bail that the defendant can make.
So I think I've got this pretty loud and clear from your motion work, but on all these, on this defendant as well as all defendants, your goal here is to set a preventative, you want a detention order, basically. Is that's what you're seeking to do?
That's accurate.
Okay,
And the bail
continue.
amounts that have been set by the district courts following the grand jury indictment. So, as we've highlighted, and I know it's pretty extensive, it's a 30-something page motion. These arrests of these defendants, it's the product of a multi-agency, valley-wide investigation through a series of incredibly violent home invasions. The crimes were, as I mentioned, violent and often unnecessarily so. Of the 3 victims who were home when these defendants were committing their crimes during the course of these home invasions, all 3 individuals, all 3 victims were sent to the hospital. One with multiple gunshot wounds, one who was bound with duct tape and pistol whipped and beaten by 4 men inside his own home, 77 years old, sent to the hospital with brain bleeds. Per his wife's own testimony at the grand jury, to this date, cannot communicate using his words and cannot use his left leg, and was still in the hospital, at least at the last.
And that's the Las Vegas case, correct?
That's the Las Vegas case. And then you have Jenny Lee, the woman who was home during the course of this home invasion with 4 other men present, who was not only beaten and pistol whipped, but also dragged in her own home to her own bathroom and drowned in her own bathtub while these individuals were trying to extract valuables from her. And I would note that they both pointed out to the police that they were trying to cooperate and were happy to cooperate. These beatings and these extra efforts and lengths they went to torture and terrorize these people in their own homes in the middle of the night were absolutely unnecessary to achieve the goals of robbing them. And so what we have, Your Honor, is, again, outlined in greater detail, incredibly violent offenses. We have an incredibly organized and sophisticated manner in which these crimes are committed. We have Defendant Queen with evidence of her researching victims prior to them going into these homes and conducting these home invasions, providing information of the victims' addresses and locations to her co-conspirators, as well as areas where they can park their vehicles so that they can get around going through security that may exist in these homes, because all of these homes are in high-end communities and they all abut either deserts or golf course areas that allow the defendants to gain access to the backyard going undetected. And so you have Defendant Queen in text messages that we outlined directing her co-conspirators where they should park their car so that they can travel to the victim's home without being detected by security in the area.
Sorry.
Sorry.
Keep going.
If you want to interrupt,
No, you're fine.
I'm happy to pause whenever. You also have the lengths that they went through, as we detailed in video evidence and text message evidence, to conceal their identity during the course of these crimes, to coordinate and organize these home invasions together. I mean, you're talking about 2 separate crews operating in unison, committing these crimes at around the same time in the same manner and fashion. There was a lot of planning and thought that went into this. And then you have their efforts during the arrests to destroy evidence, which I'll get into in a little more detail later, to flee from police in vehicles at high rates of speed, one of the defendants, Mr. McDuffie. You have defendants who have gone to every length to undermine and thwart any sort of being held accountable or when law enforcement approaches complying with law enforcement commands. So those are all concerns that I think that the state wants the court to focus on, especially when we're looking at the factors that the court considers for bail, to include the nature and circumstances of the offenses in which they're charged. So with regard to Defendant Queen, Roberts, McDuffie, and Jackson, we have this home invasion at 426 Tranquil Peak, where that's the home invasion where the victim was asleep in his bedroom when 2 suspects barged in, kicked in his door, and then shot him twice and pistol whipped him during the course of that robbery. During the course of their fleeing from that scene, we have surveillance video of them approaching from another residence, the victim's house, and then fleeing from the house. They're carrying a brown backpack that they abandoned behind. Inside that backpack is Defendant McDuffie's phone. which contains a significant amount of evidence, not just against defendant McDuffie, but also all of his co-conspirators as well. To include, if I could point out to the court, text messages between defendant Queen and himself, where she is actively advising him that she knows the address of a YouTube personality which matches our victim in this case, that he lives in Las Vegas, and is coordinating with defendant McDuffie on when he's going to travel to Las Vegas so that they can touch base and ultimately commit this crime that's detailed in these pages. Defendant McDuffie confirms the identity of the victim that they're looking at when he comes to Las Vegas by telling defendant Queen that he's going to move to Vegas and we've got to do that. And when she says, do what? He replies, CJ. Then you have January 10th of 2023, defendant Queen coming from California to Las Vegas, and they're discussing getting together to commit this crime. And then on the 11th, in the hours before, you have defendant Queen providing defendant McDuffie with the victim's address, as well as where they can park to commit the crime. And then you have defendant McDuffie advising defendant Queen during the course of the events, right before they go in, that they're going to go forward because they know that the victim is asleep, that they've seen his cars, and that they moved the victim's cameras. And I would note for the court that on this victim's house, he had cameras that had been deactivated that were destroyed or pulled from the wall that we saw the other defendants do in similar home invasions in this case. You also have defendant McDuffie texting with defendant Roberts, who is the driver of, that drives all the co-conspirators to this event. He's not only coordinating and discussing the use of firearms, but also coordinating addresses for all the other co-conspirators on where to pick them up. Defendant McDuffie is texting defendant Roberts.
So if we can concentrate on Queen at this point.
Sure.
Just, I know they're very involved, but I want to do an individualized determination on each
Understood.
independently.
And Your Honor, I would note that my client is not on today, so we shouldn't be arguing my client.
This is Ms. Brown?
Yes, Your Honor.
Well,
Okay.
I'm going to discuss the evidence as it interrelates to all the.
Sure, if it has some nexus, but if it's between two other co-defendants, constrain that till the point where we get to that person.
Okay.
Okay.
What you do see as we detail text with the other co-conspirators, and the text to defendant Roberts do relate to defendant Queen because they are carbon copies of defendant Queen's texts to defendant McDuffie of the address and locations to park, forwarded on to yet another co-conspirator who is the driver of this situation. You also have defendant Queen associated with these multiple home invasions committed by defendants Washington, Lee, Cabot, and Butler. We have the home invasion videos from January 11th, where you see two home invasions where the victims aren't home. We provided the court with video surveillance from both of those incidents. We provided the court with video surveillance from the Cancun resort where the defendant Queen was staying and was essentially a headquarters where these crews would come and either stay with her or meet with her prior to committing these offenses. We have defendant Queen registering at the Cancun resort using the phone number we know to be hers that all detailed records show her in the area of each of the events charged with that are the January 11th home invasions and the home invasion at Queensbridge. We have her with her co-conspirators going into their hotel room after defendant Queen checks in. Then they get changed into the clothes that you see them in during the course of these home invasions that are captured on tape, which is the dark hoodies, the dark pants, the masks, etc. And then they're captured leaving defendant Queen's hotel room, getting on the elevator and leaving right before these home invasion events take place. And again, defendant Queen, as far as the January 11th home invasions and attempt home invasion, defendant Queen's call detail records show her traveling from the Cancun to those locations as well. Again, while we're not saying she went in and she's organizing and coordinating each of these events, she was nearby during the course of those home invasions. Then you turn your honor to the January 12th Queensbridge home invasion. This is the one in which the victims were bound with duct tape, pistol whipped, and Ginny Lee was drowned underwater in her own bathtub. You have, again, video evidence of them leaving the Cancun in the clothing that is similar to what was described by the victims. You have the victims reporting 4 black males coming in. That's again consistent with the 4 individuals that we've charged that were leaving the hotel at the same time. Then you have we have phone records from defendant Butler showing him in communication with defendant Queen on FaceTime during the course of the home invasion. Defendant Butler is outstanding right now, but his phone, and I'll get to the arrest in a moment, his phone was recovered from the arrest of defendants Washington, Lee, Queen, Cabot, and Butler. All of them were arrested inside a home coming back to Las Vegas some weeks after these events. And inside that home, multiple phones that had been destroyed. One was still intact enough for them to conduct a forensic download. That was defendant Butler's phone, which again ties back defendant Queen to each of these events because during the January 11th home invasion and attempt home invasion, we see one of the suspects on a phone, as if on FaceTime, speaking with someone throughout the course of the home invasion event. Records show defendant Butler, who again searched these victims' residences where they are at, is on the phone for his own phone records with defendant Queen at that time in communication throughout each of the home invasion events. That victim Jenny Lee stating that the male who was with her that put her under the bathtub was also on his phone during the course of this home invasion event, and he was speaking to a woman on the other end of the line. You could hear it was a woman's voice. He was providing updates as to how the robbery was going. We have phone records from defendant Butler's phone showing him in communication with defendant Queen at the time of the home invasion event that took place at the Queensridge. You also have social media records from defendant Queen showing that during the home invasion, while these men are in there torturing these people to extract money from them and get them to open safes, she is searching on Facebook the victims' names. And these are very unique names, Your Honor. These individuals are of Chinese descent, and they have very distinct Chinese names that would be listed in the statement of facts I provided. But it's I want to just say it for the record. Give me one moment. It's Zhengni Li, that's Zhengni. Li is L-E, and Hong Shu Lu, and Lu is L-U-I. You have defendant Queen on Facebook while the home invasion is taking place, searching multiple variations of those very specific names. Then you have Instagram records of defendant Queen after the fact, attempting to sell a Birkin bag and a Chanel bag that belong to the victim, Jenny Lee. And they're very unique bags. One of them was discontinued. Ms. Lee was able to identify. The Birkin bag was a unique teal color and had a very specific scarf wrapped around the handle that again, defendant Queen is attempting to sell in the immediate aftermath of this event, and that Jenny Lee was able to identify as hers. Then you have video evidence, Your Honor, of the defendants immediately after this robbery event, fleeing the state and heading back to California. And our phone detail records corroborate that as to defendant Queen, but beyond that, we have video evidence in Barstow where they stopped at 1 in the morning after they're fleeing the state to get gas and grab a few snacks. And they're still wearing the same clothing that they were seen wearing. Again, as you see defendant Queen, defendant Lee, and defendant Butler all together in that convenience store on their way back to California, showing that they're together before, during, and after these events. And again, a lot of this is going to overlap as to each of the defendants as we move forward. The last thing I would point out off the top of my head with regards to defendant Queen, Your Honor, as far as the evidence in this case, is, again, as I mentioned, the arrest that we detailed in our motion or opposition in this case. The criminal apprehension team and other detectives had learned that defendant Queen and one of her co-conspirators, at least from the call detail records they were up on with the evidence they had at the time, were traveling back to Nevada. Wanted to obviously take them into custody for these offenses. During which time they traveled to a home where there's an Airbnb. They're driving in the same suspect vehicles that we've seen them using throughout the course of these events that I've described. and they go inside the residence, and officers attempt to make contact, and there's no response. And they end up in a standoff for over 2 hours, during which time detectives call defendant Queen on her cell phone, the cell phone that she used to register at the Cancun resorts when these crimes were committed, the cell phone that is at each of the different events that I've outlined to you and that are outlined in our opposition. And she answers it. They ask her to come out. She says, "We'll be right out." Another hour goes by, during which time they are inside destroying every single cell phone they have on, destroying evidence of this case. Pure consciousness of guilt. It's, again, one of them they didn't destroy enough we were able to get into and was able to shed a lot more light on what was happening in this case. But that's what they did. They hid firearms. 3 firearms were hidden in the attic of the upstairs room. Firearms, that one of which was a small framed handgun that was consistent with what one of the victims from the Kingsgate court relayed the firearm looked like. It was a smaller handgun, smaller than what the officer used. You had evidence that they were not only hiding the weapons, but that there was cleaning solution nearby, and detectives believed that they were destroying biological evidence, DNA evidence that may be on those guns. So what we have is an individual, all these individuals, who is, this one in particular, who's Queen, leading these events, who is overwhelmingly tied through forensic evidence, phone evidence to these events, and video evidence, and leading a very sophisticated operation, running 2 different groups to committing each of these home invasions that we detailed here. Then when the police arrive, she's destroying evidence. Outside of that, Your Honor, and again, I think just with the evidence of the case alone and the underlying nature of these facts merits the bail setting that we have it at. Outside of that, you look at the fact that defendant Queen has no known ties to this community, that she's a documented member of the Grape Street Crips out of California. She has a gang-affiliated omerta tattoo that she shares with a couple of her co-defendants, to include defendant Washington, which references a mafia code of silence. She has convictions out of the state of California for burglary in 2017, 2 counts of receiving stolen property in 2017, and another burglary in 2011. On top of all that, she had pending burglary charges in the state of California when she traveled here to commit these crimes. So the bail setting, Your Honor, was originally placed at $500,000 in Justice Court in Henderson. That was transferred. That was only charging. That was not charging the home invasion events of Queensridge, where these people were beaten, bound in duct tape, and the female was drowned in the bathtub. And it was carried over when she was indicted on those offenses to $500,000. With the additional evidence and the additional counts from Queensridge, which the superseding indictment was filed, the court sought fit to raise the bail based on good cause because there were 10 new felony offenses, of which were incredibly egregious and violent criminal acts committed in these victims' homes that merited the increase in the bail setting. The court issued the superseding indictment warrant for arrest. So if the court has any specific questions beyond that, I'm happy to answer them, but the bail setting in the state's position is that the bail setting is appropriate, given these offenses and given her criminal history, and that it should stand.
Ms. Rasmussen, did you want to have a final word?
Yes, just a couple follow-up items. So as you have heard, the state doesn't contend that Ms. Queen was present at any of these events. Their contention is that she organized them. The conduct that the state describes as being so egregious, which is discharging a firearm, actually shooting people, tying people up, none of that is something that she's present for. While they identify a female voice, they cannot identify that that is her. Half the population in the United States are female, or more than half. But I'm not trying to minimize the allegations of the state. What I am saying is, and it's true, she doesn't have ties to this community. She has lived in Los Angeles her entire life. But what I am saying is that the state is essentially asking you to set no bail, because that's what $1 million is. That's what $500,000 is. And so, while I certainly, believe that the court is inclined to set a high bail, why does it need to be $1 million? Why does it need to be $500,000? She can't make any of it. And so there needs to be a particularized finding in this case that's appropriate given the circumstances of this case. And that was why I asked you to set 100,000 because I don't even think she can make that.
Could I add one more thing? Just because there was a lot and I forgot something. And again, this would go to one of the factors of course to consider the likelihood of more criminal activity if the person should be released. I would just note in Defendant Butler's cell phone that was found after that arrest and forensically downloaded, there is a group text thread between the defendant and defendants Washington, Cabot, Butler, Lee, and defendant Queen on their way to Las Vegas. And in that text thread includes a video sent by defendant Queen that she is narrating of a victim's home, I would imagine in California, where she's driving by a high-end home that's behind gates. She's filming it. She's noting where the surveillance cameras are on the house and how she and her crew that she's texting can basically crack into this home. So I think there's a high propensity and a concern by the state that there is an active, continued criminal activity, and that would be also part of our pitch to the court.
So I've heard arguments from both sides. Ultimately, these are highly coordinated, very violent offenses. In general, the likelihood of conviction is very high involving the CDRs. I think there may be some legal issues. Obviously, we're going to flesh those out as the case goes on. But at this point, with what I have, I don't think that there are any non-monetary conditions that can keep the community safe. I'm not really even considering whether she'll come back to court or not, because this is just above and beyond what we see, even in home invasions, which are some of the more terrifying offenses that we deal with here. And then I add into that just the fact that she has priors for this in her level of involvement here, and I think a high bail is appropriate. I'm going to set bail in this case at $750,000. I'm not going to insert the condition of high-level electronic monitoring because that doesn't work with her California ties. It is meant to be a detention order, so I don't know that high-level electronic monitoring means anything. There also is the condition that she has no contact with her co-defendants or with any of the named victims.
Thank you.
The next case we're going to move on to will be 28, Ms. James client.
Thank you, Your Honor.
Okay, on this one, you may be heard. Go ahead.
Your Honor, I did file a response.
And
to
I
this
did
case.
review that.
Thank you. I apologize because I filed it very late in the evening of Saturday, and I wasn't sure if the court had a chance to go.
I did review that. I think that was filed yesterday, but I've reviewed them all this morning. I'm trying to get up to date on this case.
Thank you, Your Honor.
You are asking for $50,000 of high-level electronic monitoring, citing his ties to Las Vegas as well as California's limited criminal history, and the fact that these charges were known to the DA at the time of the grand jury.
That's correct,
First grand
Your
jury.
Honor. And with
Okay.
respect to that, the difference, I guess, with some of us here is that I substituted in for Mr. Gruber. I did know that likelihood, generally with these type of cases, grand jury indictments are very common. There was a Markham notice that was given to us. Markham notice listed all three of the events, listed all of the charges that ultimately Mr. Washington stands indicted on. I did respond to the state in regards to the Markham notice. I also called the state and spoke to them in regards to the fact that I'd like to know when the grand jury is going to be presented and whether or not I reserve the right for him to testify or not. I didn't get notice of those things. Suffice to say, my advice to him would not have been to testify. That being said, where the state was going with these grand jury indictments at the time that they sought bail at any of these cases was already known to the state. The fact that the grand jury indictments were then presented in a piecemeal fashion with different events, and I understand that there's difficulty from the state's part in regards to when the evidence came into them and when they had it, but my understanding is that they knew about these events, and when they sought bail at any given time, they knew what was coming. And so I don't think it's fair to use a superseding indictment to then go back and say, hey, well, now there's 10 new felonies that we knew about all along, but now that we've indicted them on them, go ahead and raise bail 4 times without notice to me as to the fact that they were going back to the grand jury, or notice of the fact that there was a grand jury return, or any motion from the state's part to increase bail. I understand now that the state's filed this opposition in front of this judge, basically, essentially asking for a detention setting for all of these people. That said, with this detention setting of bail, it's basically a pre-punishment for what the state believes is the amount of evidence that they have in the case, and also the likelihood of conviction, as the state puts it, the many years in prison that any of them face. But what I am asking for is for an individualized consideration as regards to each of the defendants. So the state is incorrect as to Mr. Washington, that he has no ties to this community. I spoke to his mother, I spoke to his family. He has 2 maternal aunts that live here. They have been residents of Clark County for more than 20 years. They both work in the nursing industry. They provide at-home care. He has at least half a dozen cousins that would step up. The aunts reported to me that one of them lives in a specialized housing, and so she wasn't sure necessarily if she could answer right away that it wouldn't jeopardize her situation to take him, but she would serve as a third-party custodian. His cousin, Trevette Rice, has stepped up and said that if he was ordered to remain in Las Vegas, that he could stay with her on high-level electronic monitoring. What I am also asking the court to consider is that an alternative to this is that ties to a community does not specifically have to be to the community where the crime has allegedly occurred. It can be the community that he grew up in. Mr. Washington grew up in Los Angeles. He is a high school graduate. He was an athlete. He played football. He went to 2 different community colleges. He was working at the time of this offense, the alleged offense was committed. He originally was with the temp agency for about 3 years until they sent him out to Home Depot. He obviously did a good job there. They hired him on permanently, so he has a full-time position that potentially he can return to. Apparently there's 4 levels of air mobile phone monitoring that can be placed on. If the argument is that he is a danger to the community here, then let him return to Los Angeles. He can come to court when he needs to. So what I'm asking the court to do is to consider, the court will allow him to return to Los Angeles, is to set a bail in the amount of $50,000 and then place him on level 4 air mobile phone monitoring. And what it is that is monitored through pretrial services. He would go into pretrial. Pretrial will have him download the app, or they give him a specific phone to be used. That phone is tethered to an anklet that he wears that is different from the house arrest anklets. They have the anklets themselves, and the phone and the anklet is rather on a loop as to GPS monitoring. So that not only will he be able to return home to California, potentially go back to work, he will be monitored by GPS 24/7, and his location will be known if there is an argument that they believe that there is propensity for other crimes to be committed. I think the other conditions that were previously asked for on some level addresses some of the concerns that the state has in regards to, I would ask the court to enter a new order that also he is not to have contact with anyone with a gang affiliation, that he have no contact with his co-defendant unless it's in a defense meeting setting with the other attorneys, and that he is to be geographically restricted either in Las Vegas or in California, and otherwise not to leave unless he is to go to court. Just the reason why I asked for a $50,000 bail setting is in regards to this is I'm asking for an individualized consideration, and I'm also asking for parity in the case. And I think one of the issues is that without placing blame on anyone else, I think one of the difficulties for the court here is that everyone comes before this court with so many different bail settings. And I have a hard time justifying the fact that there were individualized considerations of other defendants whose known facts are not any better. And quite frankly, I agree with what Ms. Rasmussen said. I'm not trying to mitigate the seriousness of these offenses, but there were other individualized considerations, and I find it hard that some people were given an OR release with house arrest, and then we have people who have bail set as high as $250,000, $1 million, $500,000. That consideration was never made, because what the state said today is that they're essentially seeking a detention order. That has been true all along, from the start of the case to present. and I'm not sure that those individualized considerations were made. I don't want Mr. Ports to have to repeat all of what he said as to the individualized consideration compliance. I will point out that one of the things that was placed in the motion in regards to the belief as to my client's culpability is that DNA evidence was found on the scene of the King's Court Gate event. And with respect to that, I did review the DNA report, and this is a Bell hearing, and where weight of the evidence is a factor to be considered, it should be really because the presumption of innocence still attaches. It really should be the lesser of the considerations. However, that said, we're talking about one piece of duct tape that was essentially swabbed in 8 different places. Every place that they swabbed has come back with at least 3 to 4 contributors. And to the extent that multiple defendants' DNA were found on that piece. There were so many pieces of evidence. There were at least 2 pieces of evidence in which he was excluded, and then there were multiple pieces of evidence in which it was just, you can't tell, it's just too much of a mixture. There is a cutoff as to reporting for what is included. However, based on the court's experience and what we've normally seen in the case, we're looking for an exponential number that is severely high. It is not as high as one would think for it to be in this case. It meets the cutoff definition, but it also is a piece of evidence that I have a mixture of DNA and multiple contributors, and you can't specifically tell. And quite frankly, I think that's one of the issues, is that when we talk about destroying evidence, when we talk about somebody else is the ringleader, when we talk about something else that has happened, from what I've read thus far, and without the benefit of the superseding indictment transcripts, I don't know specifically what is attributed to my client. What I do know is attributed is that we have similar looking clothing, and then as to that event, we're talking about what is some DNA evidence, and whether or not, I don't think with a straight face I can mount an argument that he didn't know his co-defendants or that he wasn't seen around his co-defendants, but whether or not there is some trace DNA evidence and whether or not that's natural or not natural given their close proximity, I can't speak to that. But when we're talking about we don't have x-rays behind a house, I can't attribute to him that he did anything to destroy evidence, and I don't think that the state should either with regards to that. So with that, I'm going to ask the court to, in your discretion, I guess there's something to be said for that. He can remain in Las Vegas. He has ties to Las Vegas. But the fear is that he remains a threat to this community here. Ordered him return to Los Angeles, where he will stay with his mother and sister in his childhood home. There's also technology, which the court can order, that will monitor him 24/7.
Okay, Mr. Ports, I'm seeing 15 counts on this defendant. I know Kingsgate is one of them. And then the 2 Henderson home invasions, that people were not home.
Correct.
Okay.
Yes. And again, we're going to ask that the court keep the bail at what it was set at, which was $1 million for this defendant. That was only increased from the $250,000 that was set in justice court and transferred when we indicted it. That was only increased after the Queen's Gate case was added.
And I'm doing the transfers in my head and then adding the additional things that are added.
I just bring it up because there was a lot of conversation at our last hearing, and I didn't anticipate you'd be going forward
That
about
one,
how these bills.
I have questions on a few others regarding that. We'll get to the transfer statute later. On this one, it looks like attributable to this defendant is kind of the question.
Yes, and so with regards to, again, we've discussed at great length the crimes that were committed. I would just highlight for the court that the individual in the very distinctive Puma jacket or Puma hoodie that is seen in the 2 home invasions from January 11th is the same Puma jersey that the defendant, Washington, is seen wearing leaving the Cancun resorts prior to those robbery events. Beyond that, Your Honor, I would highlight the fact, as we noted, that his social media accounts show him also putting out two of victim Jeannie Lee's purses for pictures of them, and a third additional one that I believe Jeannie Lee identified as well. But at least for sure, the two that we saw on Defendant Queens, a different photograph came on Defendant Washington's social media account of that victim's purses. And then finally, Your Honor, he was part of the arrest. He was part of the group that barricaded themselves off from officers for 2 hours, during which time evidence, to include phones that belonged to each of these individuals, were destroyed. Evidence. And then finally, Your Honor, it's two pieces of duct tape that were used to bind these victims at the Queens Ridge that Defendant Washington's team was found on. Two separate pieces of duct tape. So that, to the state's mind, is overwhelming evidence, underscores the likelihood of conviction, and ties to the offense charged. And that matters because of how egregious and how violent those facts are. Using the court's same rationale of the safety of the community, the fact that he was also in on that text message exchange between defendant Queen and Butler and the others I noted, where they're targeting yet another home somewhere in California, all underscore the fact that there's a high propensity of continuing criminal activity, and the activity that we've established through a high level of evidence that it already represents a clear threat to the community.
All right. In this case, the biggest concern for the court is obviously the most violent and latest home invasion, that Kingsgate home invasion, where his DNA is found, although ultimately there may be some legal challenges to it. Obviously, if legal challenges are sustained to any of these items, I would invite all of you to bring back these motions. However, at this point, with what I have, DNA tying him to this incredibly violent offense, and some of the sales afterwards, this is another situation where I don't find that any non-monetary conditions could guarantee the safety of the community, given the extreme level of violence that was used above and beyond what is even typical in a home invasion here. Given the charges here, what I'm going to do is set bail at $600,000 with level 4 PSU if he posts that bail.
And would Your Honor also include the no contact?
No contact with the defendant, with co-defendants, no contact with victims. PCU, not PSU. I apologize. I've been using the wrong acronym. Let's move on to page 29, Denzel Lee. Mr. Henry.
Yes, good morning, Your Honor. And just before I start off as well, I believe there are family members here on behalf of Mr. Lee. If you please would raise your hand.
Okay.
And I believe those are, just for the court's reference, to his mother, Tasha, his girlfriend's mom, Salida, his girlfriend, Jermisha, is present. I believe there's also a female cousin / sister, and there may be also two additional family member or friends that Mr. Lee had indicated is present as well. What I would highlight to Your Honor is that I think when we look at this as it relates to all the other accused individuals, is that Mr. Lee is charged with 5 counts, 2 of which are gross misdemeanors, and 3 felonies, which are nonviolent felonies, Judge. As Your Honor may recall, the state actually had to go back to the grand jury and request the additional counts from the more serious cases be dismissed. When we look at Mr. Lee's NPR, in other words, when pretrial made a determination as far as what the appropriate amount would be, what they had listed on their NPR sheet, and I know the state has referenced that Mr. Lee does have prior convictions, that was listed on the Nevada pretrial risk assessment sheet, Your Honor. So in other words, they were aware even at that time that those convictions had existed when they had put the bail setting of $19,000. They recognized that and they had listed him as a moderate risk. The other thing I would highlight to Your Honor as well, when we look at their scoring criteria too, and this was stuff that's contained in my motion, so I'm just kind of rehashing. I believe certain Your Honors had a chance to look at that motion. But when you look at the calculation, I highlighted and I provided that court docket where they put 2+ points for a pending case that was out there.
The 19,000 isn't really based on anything. It's based on what used to be standard bails, which we don't use anymore. Right?
Fair
It's
enough.
5,000 on each C felony, and then 2,000 on the gross misdemeanor. So I don't know if that's an individualized determination.
I think the important thing to highlight when we're looking at those as well, Your Honor, is that those are non-violent felonies when they came to that determination for that amount. So if that amount's 19,000, it's certainly not looking at it from the standpoint because he's not charged with any of the violent felony offenses that the other accused are.
Sure.
And then when we look at the scoring criteria, the scoring sheet as well, we see that with regards to the pending cases that are out there, he did get a +2, which is significant because I believe his total score was 6. For a pending case, which was the alleged destruction of evidence in the Airbnb residence, I pulled that up and I provided that as, I believe it's Exhibit D for Your Honor. That case shows that the state has denied to prosecute that case. Taking that into consideration, then there's actually no pending cases that are out there, which would reduce his score then and make him 4 points total. Looking at it from the standpoint as well, when we were looking at the grand jury indictment, again, unfortunately we don't have transcripts from the initial hearing over in Henderson Justice Court. We have a very limited as it relates to Mr. Lee with regards to the grand jury transcript, the original grand jury return. And then as it relates to the superseding, the second superseding, we don't have any transcripts from that either, Your Honor. And that becomes, again, a kind of a concern because at one point Mr. Lee was charged in the superseding indictment with the more serious charges. But again, the state had to go back to the grand jury in order to get those counts dismissed, which I think is important for Your Honor to recognize. I think that's unique. I've talked with colleagues trying to figure out exactly, have you ever actually seen where the state goes to the grand jury in order to dismiss counts that were previously there was a bill on, and they'd indicated they had not. So we're somewhat at a limitation with what the state is at least alleging that Mr. Lee specifically did. Reading their opposition, I recognize they put some photographs. I believe there's a photograph from Cancun Resort and also the photograph from Barstow. But one thing that I've highlighted in my motion, Your Honor, is that simply being associated with individuals doesn't necessarily mean that that particular individual is guilty of allegations that those other individuals may have committed. There's, from my understanding, no forensics. There's, from my understanding, nothing with regards to cell phones as it would relate to Mr. Lee. Where perhaps with the other accused individuals, there may be. But I've had a hard time wrapping my head around all of this because when I've looked at the original declaration of arrest from this case when it first started, there was only, I think, 1 page out of the 18 pages that referenced Mr. Lee. His name was very limited in that initial grand jury transcript. And then looking at the opposition as well, when the state is highlighting things such as likelihood of success on the merits of the allegations, they don't touch upon that at all. It's one of those things I think where their focus was on he has prior offenses and that he is an individual who has no ties to this community. I can represent his family that's here today. They are from Los Angeles, but he also does have family out here in Las Vegas. And that was part of our position ultimately today when we're going to be making the request. I know we've asked for it to be placed at the $19,000 amount. But as Ms. Zing had indicated, there is this new electronic monitoring program, the PCU Level 4, which sounds like it does a very thorough job as far as keeping, I would think, up to the minute, second, as far as where an individual's specific locations are at. From having talked with Mr. Lee, it does sound like there would be suitable residence that he can stay at with a third-party custodian. Placing him on this PCU Level 4, that can certainly accomplish something where, aside from a monetary bail setting, which he simply would be unable to afford. So in light of all this, and in light of how slim of the evidence that the state has been alleging, and in fact what the state has done by dismissing the more serious counts against Mr. Lee and focusing on what has Mr. Lee been charged with, again, 2 gross misdemeanors and 3 felonies when we look at all the other accused and what they're ultimately facing, I think Mr. Lee is very differently situated than the other individuals, with all respect. And so in light of that, I would request Your Honor go back to the 19,000, at least if that's what the standard bail schedule was, plus looking at it from the PCU level 4, because the most important thing would be the PCU level 4 would ensure that he's not a flight risk, that he would be remaining here because he'd be constantly monitored, and he wouldn't be a danger because he would also be on a monitoring system. And again, as it relates to this particular case, and in fact, even when the state highlights his prior convictions, I believe the convictions in the NPR were 2 burglaries and a felon in possession, but I don't see anything that was specifically violent in nature than either. So in light of all that, Your Honor, I would submit that Mr. Lee is certainly the 250 where we're at right now is unattainable. He would not be able to afford that.
Okay. Mr. Ports, this one seems slightly differently situated than the previous 2.
Well, I'd like to clarify something.
Go ahead.
Mr. Hendrick keeps saying he went back and dismissed counts. That's not what happened.
Okay.
And I would just note, and I will acknowledge that that's my error. I thought that his name had been removed from the superseding indictment as to the counts related to Queensridge at that time, because we weren't having the grand jury deliberate on those charges at that time. I fully anticipate that they will, and I fully anticipate that he will be indicted and charged with those offenses.
The Queensridge.
Queensridge, correct.
Okay.
But his name was included as a clerical error that I thought had been removed because they weren't asked to deliberate as to defendant Lee at that time. Now there's a reason, Your Honor, because of the lengths and the sophistication, the lengths that they went to commit these crimes, to hide their identity, to destroy their cell phones, things of that nature, and the sheer number of defendants, some of whom were let out of custody, some of whom were detained in what the state considers appropriate bail settings, that we have had to piecemeal portions of this together in an expedited fashion, and we've done as we could, the best we can with everything we've had.
When do you think that will happen? The adding in of Mr. Lee departing the King's Gate.
I don't know if I can. I would anticipate it sometime by next week.
Okay. Obviously, that is
Well,
a huge issue for
and
the
I
court.
think that the court can consider that today, not just on my say-so, but on the evidence that we've presented in our pleadings before Your Honor.
Okay.
To include, defendant Lee is with these individuals, turned first to the home invasions in Henderson without victims of harm. It means that he's currently tried. We have defendant Lee coming into the Cancun resort with the co-conspirators, all the named co-conspirators in that event, to include defendant Lee. The defendant Queen checks in, they all go up to the room, go into the room, they come out in the clothing that's worn in the robbery offenses, the home invasion offenses that are captured on camera thereafter. We presented those to the court. He and his co-conspirators are all in identical clothing that are seen at the home invasion events that followed. Then you have, similarly turning to the Queensridge case, Your Honor, is that defendant Lee is, again, leaving Cancun in the clothing that matches and is similar to what the victim, Jimmy Lee and Hong Shu, testified before black male adult suspects in their room who were beating them, binding them with duct tape. And you have the defendant and 3 other male co-conspirators. Defendant Lee is 3 male co-conspirators in similar clothing. Again, leaving that location prior to these home invasion, the home invasion of Queensbridge. Okay? Then you have, when that concludes, late in the evening of the 12th, you have all the defendants immediately driving back to California and are seen in Barstow at that Chevron. Defendant Lee is on tape with defendant Butler, whose phone was actually hanging inside that residence, and who went through all those communications with all the other co-conspirators about the Queensbridge robbery and the other 3 robbery events. They're all together on their way back to California. Then you have from defendant Butler's phone, Your Honor, again, them all coordinating to come back to Las Vegas on the day of their arrest. You have a video from defendant Queen to defendant Lee and others discussing the showing a video of a new target home, discussing where the security cameras are and how they can hit that home. And then you have him as part of a group that was inside the residence that had a standoff with police, at which time the phones were destroyed. So no, we don't have phone evidence as to defendant Lee because his phone was presumably amongst the
So
phones
your
destroyed.
belief going forward this case before in Queensgate, Lee, Washington, Butler, and Cabot.
Correct.
I'm going to continue this OR motion to next Wednesday to see if that's filed. Otherwise, I'll go forward with what the evidence that we have and what I think the bail should be set at based on those. But I'm giving you a week and a half to get that in order. Page 30, Sean Jackson, Mr. Patrick. Okay, this one I'm going to start with Mr. Ports. Mr. Ports, pursuant to, you didn't address in your motion what I was looking for, which was Nevada Rule of Criminal Procedure 5, which has a rebuttable presumption that bail will transfer from justice court unless you can present a change of circumstances on record to have those conditions changed. So what I'd like to do is talk about what was presented to the Justice of the Peace that resulted in this bail setting, and then what is additionally available, if anything.
I don't believe I would be competent to speak to what I did not handle this particular court.
Okay.
And so I would hate to. I don't want to make any representations that are incorrect.
Okay.
I can request transcripts from those, and I can advise the court in candor that. Well, I don't have any additional representations.
That's
to
okay.
make on that.
Okay. So in general, then, what changes have been made since the bail was set by the Justice of the Peace?
Your Honor, just that I, as far as, again, I don't know what was presented to the Justice of the Peace, so I apologize for not being prepared on that point. But that there has been the evidence that was presented to the grand jury in the indictment that has ensued that shows the text messages between defendant Jackson and McDuffie leading up to the home invasion event at Tranquil Peak home. This is where the victim was shot twice in the legs. And we have text messages between defendant Jackson and defendant McDuffie, in which defendant McDuffie is stating to defendant Jackson, condolence, we're hitting CJ So Cool house tonight. DJ So Cool is the moniker of the victim on YouTube. You ready, cuz? All black, hit you up tonight. Defendant Jackson then asks defendant McDuffie to pick him up, and then he sends his own address to an address immediately adjacent to his home to defendant McDuffie, which defendant McDuffie then shares with defendant Roberts, who is driving the suspect vehicle that is seen going to and from the residence, and in surveillance video outside the victim's house showing 4 suspects approaching and leaving. For the court, those 4 suspects will be defendant McDuffie, defendant Jackson, defendant Gayosa is an uncharged co-conspirator who's still in juvenile court proceedings, and defendant Roberts. And I would note that at the grand jury returns, I do know the district court judge, Judge Jones, was advised that both defendants McDuffie and Jackson, their custody status, the release terms that they have been issued in justice court, and then after being advised of the facts underlying the case, issued the bail amount that we have them in at now. And if that court had maintained the bail setting that was at, we would have filed a motion to address bail in this court.
So it's your representation that these texts that were presented to the grand jury are something that was obtained later in the case, in the investigation?
That I don't want to speak to that. I don't know if that was represented to the justice court or.
Okay.
So,
I also did see in the justice court minutes something about it was continued for filing, and so maybe I don't know if it was a kick out or if it was just continued one day and the bail was set. I didn't have the minutes, and I was trying to get some information from you about that, but it sounds like I don't know who was present at that time.
I believe it was District Attorney Walsh, but I will verify
Okay. Will you be able to get a transcript of the proceedings in front of that justice of the peace, and like before, if I continue this to Wednesday?
I will request that I request that they be expedited.
Okay, because that's my only question really left in this case is whatever was known then, we're stuck with it. And if there's a situation where you have more information, I need to know that. But if not, the bail should have transferred. And so I want to see that transcript so that you can make a full argument on that. And I'm going to continue this till Wednesday to get that transcript.
Your Honor, I've been here for an hour and a half, and I want to make a record. And I don't want to wait till Wednesday. Everybody else has made a very detailed record, and I should have the same chance to do that. And I can answer your questions, because the text messages were in the original arrest report long before the grand jury met. All right? Sean is in a different position than everybody else. He's 16 years old. He was granted an OR with high-level monitoring. What did he do when he get out? Well, he went and lived with his aunt, and his aunt's here, and his uncle's here, and his mom's here, and they've been to every court appearance that he has had. He's born in Las Vegas. He lives in Las Vegas. He's not from LA. He's been working. He wasn't causing trouble. He wasn't a danger to the community, and he wasn't fleeing. He was out. He was doing well. Now, let's talk about the grand jury. So when the criminal complaint came down, he was charged with 7 felonies, all D felonies. They go to the grand jury. The first indictment comes down. He still has 7 charges, but now 5 are felonies and 2 are gross misdemeanors. So Mr. Quartz has been here all day talking about transfer and, well, the charges went up or there was more charges, so we increased the bail. On Sean, the charges went down. And knowing that the text messages were out there before, they were in the original officer's report, and his charges went down, there was no reason the bail should have been raised in this case. He was not one of the people that ran to California. He was not one of the people that you saw in Barstow. He was not one of the people that barricaded themselves for 2 hours. He was not one of the people that destroyed evidence. He is he's charged with allegedly 1 event. Not 5, not 10, not this whole thing. 1 event. And he's been in Las Vegas. He was out, doing well. His charges went down, yet his bail went up. Now, I don't know how you explain that when Mr. Quartz has been sitting here saying, well, we got more charges, so the bail has to go up. His went down, and his bail still went up. I don't think we need to wait till Wednesday. The text messages were there in the original police report that we got. He needs to be put back on that same bail, OR, with high-level monitoring, and let him out as he was before. He wasn't causing trouble. He wasn't rearrested because he was out creating more crimes. He was out arrested because grand jury's secret, return is secret, and we had no idea this was going to happen. And I believe that's all I got, and I'm sorry for raising my voice, but in his case, this is really a travesty of justice that his charges go down and his bail goes up. $250,000. I don't know, I don't personally know any 16-year-old that can come up with $250,000. When I was 16, I sure couldn't. Maybe Bill Gates could have, but other than that, he was out, he was doing fine, charges went down, bail went up, makes no sense. Thank you.
Mr. Quartz, do you have anything to rebut what Mr. Patrick said today as you stand here regarding change in circumstances?
I don't understand.
I'm going to reinstate the bail that was set by the Justice Court of your release on high-level electronic monitoring.
Thank you, Your Honor.
Just high-level electronic monitoring. It's house arrest. Page 31, McDuffie. Is there a change here that you can address at this time, Mr. Quartz?
And Your Honor, I cannot represent what representation was made at the Justice Court hearing when that bail was set. I can only highlight the evidence that we've since presented to the grand jury.
So I see there's at least 2 different incidents here. Were both presented at the same time when you initially presented this case?
To the grand juries?
No, when this case first went through to Justice Court.
Yes.
Both incidences are in the
Both
original.
incidents were pled in the justice court case.
Okay. I'm going to hear from Mr. Rutledge, then I'll turn to you second. Go ahead, Mr. Rutledge.
Your Honor, in this case, and I think one of the reasons that Justice Lefty set the bail on is we have a 16-year-old young man here. And this isn't a case where this came up because he has an extensive criminal history in the juvenile system either. It came up automatically just because of the charges. He doesn't have any prior robberies or burglaries or anything like that in juvenile. He's not involved in the destroying evidence. Here in court today is his uncle. His mother's brother is here in the back row. He was all set up. When he was put on high-level electronic monitoring, his mother made plans to live with her brother here in town with her son. But she wanted to make sure that he didn't get in trouble, that there was no problems. And she had to take care of a sick relative in another state. So she delayed picking him up on house arrest until she could be there herself. And then she goes to the jail to pick him up, and they said, oh, there was a grand jury indictment returned, and you now have a $250,000 bail, which obviously neither she nor he can make. And she's prepared to take him back out on house arrest. He does have a place to stay. His uncle, her brother, his uncle has lived here in town for more than a decade. Lots of ties to the community. He's not going to be a risk of the high-level electronic monitoring. We'd ask that you reinstate those that as his bail.
Go ahead, Schwartz.
Your Honor, defendant McDuffie's phone is one of the key pieces of evidence in this case. It links defendant McDuffie to the C.J. Sokol home invasion and shooting, and shows that he was a key player in instructing and setting that went in and committed these crimes. Not only that, Your Honor, but after that offense, he committed an armed carjacking with another co-conspirator, at which point in time, while the victim was being held up with a gun and being robbed in his vehicle, defendant McDuffie, who was identified by the victim, made a clear statement referencing C.J. Sokol claiming responsibility for that individual being shot as a means to intimidate and effectuate the robbery of that victim in his car. Beyond that, the police attempted to stop defendant McDuffie was driving a high-speed flight away from police that exceeded speeds of 90 miles per hour and were struck vehicles, struck oncoming traffic, and then fled, abandoned the vehicle and fled into a residential backyard before he was apprehended by police. He was identified by the victim, and the gun used in the robbery was found in the victim's car, which was right in the immediate vicinity of he was taken arrested. So, again, I can't represent what was stated to the Justice Court. I can tell the court that while those text messages between defendant Queen and defendant McDuffie and one of his other co-conspirators are referenced in the arrest report, there was additional evidence pulled out of that phone that tends to more strongly continue to tie defendant McDuffie and his co-conspirators to the crimes that we charged. And that it would, the fact that he has been indicted on those cases and that we've additional evidence connecting him with his co-defendants would be, to the state's mind,
so you believe that likelihood of conviction is higher than when this was previously presented?
Correct, as opposed
what,
to...
What would that include?
I would... Well, again, the items that we've highlighted from Dolan's there's been a significant amount of evidence pulled from defendant McDuffie's phone at this point in time off the top of my head. I hate to provide this answer to the court. I don't know what was told to the Justice Court when that release was set. I would have the full transcript, so I don't know what was conveyed to her. But obviously, as we've gone through the phone, and part of that was presented at the grand jury, I believe, and would have to supplement at this point in time. I don't want to speak off the top of my head. Supplement with what I believe might constitute additional evidence for the time defendant McDuffie concealed his crimes. But I would again highlight that the district court judge was advised of defendant McDuffie's release status before determining the need to set the bail at the $250,000 that ultimately was set at.
Your Honor, I'd just say that based on when I was appointed in this case in Justice Court, I got the a declaration of arrest that was read by the justice of the peace to find probable cause to even hold the bail hearings. And it contained all these facts. It contained about the 2 offenses that this defendant is charged with. They did get information off a phone that was found not on him but on the ground, and that information has been used to put together their case. But it was used to put together the case by the police before people were arrested on it. This was all in the affidavit of arrest.
And then ultimately this was set at the arraignment court and then readdressed by Judge Goodman, correct?
It was never readdressed by
No, it wasn't. Correct. It was just set at arraignment court. We
Okay.
said we would readdress our release.
One that was filed. I was confused about why there was a delay in filing, but I guess, I don't know.
There was a certification procedure in place. Was originally charged in juvenile court.
So they certified this up between the time that you appeared in front of Judge Sachs and then when it in front of Judge Goodman?
It's an automatic cert.
It's an automatic cert because of the gun.
Okay, maybe I misunderstood what the court was stating. I don't know what the delay was between Judge Sachs and Judge Goodman.
Okay. At this time, I don't find there's a change of circumstances necessary to challenge that rebuttable presumption that the bail should have been transferred from justice court. Bail is reset at an OR with high-level electronic monitoring, no contact with co-defendants, no contact with victims. It's high level. We can do high level, we just can't do